You're live now.
Okay. Hello, I think we'll make a start. My name is Gary Spence and I am the ASGBI Regional Rep for Northern Ireland. I'd like to warmly welcome you all to this ASGBI webinar on the subject, medical legal aspects of surgical practice. Having only recently assumed the role near the start of lockdown, I was exploring how I might best promote ASGBI to the busy practicing general surgical fraternity in Northern Ireland. And when I was discussing what I could do with Bhavnita Patel, the ASGBI general manager, she suggested that other regional reps had successfully hosted educational webinars. As such, the next step was to identify subject matter that had general appeal to all practicing general surgeons, regardless of their subspecialty interest. So unfortunately, it is increasingly likely that all of us will at some point in our careers have cause to have dealings with our colleagues in the legal profession, whether with litigation, with a coronial inquest, or unfortunately with the GMC. Such dealings can be extremely stressful, particularly when our professional reputation, our livelihood, and even our liberty might be in jeopardy. Tonight, we are fortunate to have 4 highly experienced experts, some of whom remain my friends despite my coercion to get them to present tonight, who are willing to give of their time and expertise to educate us in their respective medical, legal, and/or surgical fields. Following 4 15-minute presentations, our presenters will be joined by our ASGBI Vice President, Mr. Neil Welsh, for a panel discussion around some of the topics raised. If you have any questions for any of the presenters, please forward them to us via the chat function and I will ask them on your behalf. We will leave question and answers to the panel discussion rather than after each individual speaker. And after the panel discussion, Neil will close the meeting. And finally, before I introduce the first speaker, could I ask you all that following the webinar, would you be so good as to complete the feedback questionnaires that Bav will send out to you in order to help us improve our webinar series? And on receipt of the completed feedback questionnaires, you'll receive a PDF certificate of attendance that you can add to your appraisal folder. So our first presentation, The Surgeon in the Law, Friend or Foe, is being delivered by Judge Philip Gilpin, County Court Judge. Judge Gilpin was educated as part of the master race at RBAI and latterly at Queen's University, Belfast. He was admitted to the role of solicitors in 1994, being engaged in private practice until 2010, when he was appointed solicitor to the Attorney General for Northern Ireland, a post he held until 2012 when he was appointed as a district judge. In 2019, he was appointed County Court Judge. Alongside the usual practice of a County Court Judge hearing criminal, civil and family cases, he also presides over legacy inquests and assesses compensation claims for those who were formerly residents in children's homes in Northern Ireland. When not working, you might catch him out on one of his bicycles, but you would have to be pretty quick to do that. Judge Gilpin, over to you.
Well, good evening. Thank you, Gary, for those words of introduction. It's the second thank you I have for Gary this week. Some of you will see Gary sporting a couple of injuries to his face. He had a fall when he was cycling the other night, and I was with him. And he was kind enough to break my fall and cushion me from the effects of the road. So thank you, Gary. Gary has given you a little bit of a resume of my professional background. It's perhaps taken a bit of a different course from some of yours. I suspect for some of you, you will have moved from perhaps a fairly generalist approach to your work when you started off to a more specialist approach. I have gone the other way. While I was in private practice and in the attorney's office, my practice was specialist in nature. But now the type of work that I'm engaged in is of a fairly broad base. And it's from that broad approach that I want to speak to you tonight. Others who will come after me will speak of matters of detail. But I want to begin our evening together by painting on a fairly broad canvas. And I've taken as my topic tonight the title, The Surgeon and the Law, Friend or Foe. And what I want to do over the next few minutes is to think about some of the occasions when you as doctors may encounter various legal processes and to ask whether those encounters are, in the general scheme of things, a good thing for doctors, or are they not? Let me be right up front with you as to where I want to go with this. I want to acknowledge that very often where doctors have to engage with various types of legal process, that process of engagement can be, to use a neutral term, somewhat unpleasant. And perhaps others will speak about that later. But the broad theme that I want to develop tonight is that your engagement with various legal processes is a matter that can bring about considerable benefit for the medical profession in particular, and for the general public as a whole. So that's where I want to go. Let me just develop then my argument, and you can see what you make of it. It may be simply a statement of fact that in our developed Western democracy, we live our lives, including our professional lives, governed by the rule of law. Thus, in my professional life as a judge, I'm governed by the rule of law. So in the Crown Court, if I have to sentence an individual, I'm not free simply to go off on a frolic of my own and pick whatever sentence I just happen to choose. Rather, I'm constrained by perhaps matters that Parliament has laid down or the higher courts as to how I must approach my task. I'm very much governed in my professional life by the rule of law. And of course, in your professional life as doctors, you live under that same broad umbrella governed by the rule of law. In the important case of Montgomery that I know that Gordon's going to talk a little bit about later on, in 2015, the Supreme Court, the highest court in the UK, changed or developed the law in one particular area of medical practice. And since that case has come into force, many of you will have had to adjust your practices as you comply with the rule of law. One particular example of compliance with that general rubric of the rule of law governing us. So that's a fact that we all live under and practice under the rule of law. And I'm going to assume that for tonight's purposes, that of itself is not a controversial notion. But what I want to spend the rest of our time together this evening during my part of the presentation is to look at the attitude that we adopt as we live under that reality, as we practice under the rule of law. In short, how do we regard this thing that constrains us? Do we regard it as a foe out to cause us difficulty and to cause us harm? Or rather, do we regard it as a friend that exists for our benefit? So what I'd like to do is to look at some general legal processes which you as doctors might in the course of your professional careers encounter. In order to give a little real life context, what might otherwise be an academic discussion, I want to talk about 4 legal processes, and others may talk later in detail about some of these, but let me just paint a very broad picture of them. They're criminal processes, criminal justice, coronial inquiries, wider public inquiries, and matters of civil justice. So first of all, criminal justice. In its most basic form, the criminal law exists to deal with situations where the conduct that is in question is of such a serious nature that it's not just the individual who considers themselves to have been harmed that seeks redress, but rather that society as a whole seeks that. So thus in a medical context where a complaint is made to the police and the police believe that the relatively low threshold requiring an investigation is met, they investigate. Then the higher test that the public prosecution have to adopt, that a prosecution should be brought, that is met. A doctor could find themselves potentially in front of one of the criminal courts where their actions will be considered as to whether or not they would constitute a criminal offence as having occurred. And of course, if it is found that a criminal offence has occurred, that will lead to a sanction being imposed. It can range from a fairly minor sanction to a serious one and perhaps even a custodial sentence. Now, it's of course rare for doctors to find themselves in such a situation, but it does happen from time to time, and you'll all be aware of that. Those are cases that understandably tend to hit the headlines. Shipman, Bramwell, you might remember he's the surgeon who branded initials onto the livers of some patients. It was the case of Sarker, the doctor who exaggerated his qualifications and was found guilty of committing a fraud. Obviously, an offence like that can put patients at considerable risk. So, situation number 1, criminal justice. Situation number 2, process number 2, when you might encounter a legal process, are coronial inquiries. Now, Joe's going to say much more about this in a few minutes, but in its basic form, a coronial inquiry is a legal process where an independent judicial investigation takes place into the events surrounding a sudden, an unnatural, or an unexplained death. And from time to time, you as doctors may find yourself involved in just such an inquiry. And I'm going to mention a couple later on. And then, of course, there are wider inquiries, wider than just coronial inquiries. Coronial inquiry will deal with the specific and discrete issue where death has arisen, but there can from time to time be wider inquiries where a minister deems it appropriate because of matters of public concern for a public inquiry or other form of inquiry to take place. Again, those inquiries seek to look at such issues as, well, what actually happened in the particular circumstance? Why did it happen? And importantly, what can be done to prevent it happening again? And of course, in this jurisdiction in Northern Ireland, we have seen examples of that. Historically, we've seen the hyponatremia inquiry chaired by Mr. Justice O'Hara. That is an inquiry of which its recommendations attracted some notoriety, reporting in January 2018. And at present, there is the ongoing neurology inquiry into matters concerning the Belfast Trust. So criminal justice, coronial inquiries, wider inquiries, and then finally civil justice. In the civil justice process, an aggrieved patient, a patient aggrieved by the actions of a doctor, may commence legal proceedings against that doctor and or perhaps the trust who the doctor was working for. There they seek to persuade a judge that the doctor owed them a duty to take care and that the doctor in their actions has breached that duty. And in breaching that duty has caused them damage which should be compensated by an award of money. Now, just a comment in passing in relation to the general approach that the civil law takes where the plaintiff is alleging that the actions of a doctor have in some way been deficient. Gordon's going to mention this case again in some detail later on, but the general standard that is expected by the civil courts goes back to a 1957 case called Bolam, where the standard that the civil courts will generally look to is, well, what would a general body of surgeons in your case getting together and saying, well, what would be the reasonable standard that we would expect to take place in a situation like this? And so in this particular aspect of justice, great deference is given to the views and the experience that doctors acting as a whole take of a particular situation. Now, those are the four processes that I wanted to mention to you, four real processes that from time to time you might encounter in the course of your professional career. I want to go back to our question then to think about those processes and to ask ourselves whether they might be processes where we meet a friend or where we meet a foe. And I want to suggest there are perhaps two reasons why you might think that you're meeting a foe. Those two reasons relate to the outcome of the processes and secondly to the process themselves. In terms of outcome of those processes, outcomes of any of those legal processes for any doctor caught up in the particular circumstance can be difficult. In criminal courts, as I've mentioned, while the sanctions can range from the most minor, they can on occasions lead to a custodial sentence. In the civil courts, if the process turns against the doctor, an award of money will be made and damages will have to be paid. And of course, that relates to the importance of being properly insured. And I think Neil's perhaps going to mention that later on in our time together. Perhaps the most common form, though, of outcome concern about any of those legal processes is the issue of public comment on the doctor in question. During any of them, there may well be press reporting taking place. At the end of them, there may be a written judgment or a report. And that can, of course, expose the doctor's actions to wider scrutiny and to comment, whether that be informed or uninformed comment. No one enjoys having their homework marked, and to do so in such a public way can, of course, be understandably difficult. So the first reason why I want to suggest that doctors may often regard those legal processes as a foe relates to outcome. The second reason relates to the process themselves. By its very nature, such processes can be slow, they can be much delayed, and they can make great demands on your time. I understand entirely why that would be frustrating for you as medical practitioners. On one view, it diverts you away from your frontline practice with presenting patients and takes you into an unfamiliar world. So I acknowledge that those reasons why you might regard those legal processes as a foe are perfectly valid and understandable. And from time to time, engagement between medics and doctors can seek to improve those processes. And I'll mention one way that that might be done in a few minutes' time. But engagement with any of those legal processes can leave the individual doctors who have had to engage in them coming out somewhat battered and bruised. And I can understand readily why you may regard the law as a foe. I don't want to underplay in any sense how some of you may feel if you have had to go through one or more of those processes. But I want to return to my central argument, which is that perhaps a good way to try and regard those processes rather than as a foe is as a friend. Firstly, I want to say that it would be wrong to regard every time a doctor engages with one of those legal processes as being a time when the doctor will come out the wrong side of them. That is simply not the case. Criminal trials where doctors have found themselves in the dock do not always result in conviction. Civil cases where doctors have been sued have been lost. Coronal inquiries, rather than having been critical of doctors, have been complimentary of them. One coronial finding that I read, where a child had sadly died in the Royal Belfast Hospital for Sick Children, the finding of the coroner indicated in his words that the actions of the medics there were beyond reproach. So thus, on occasions, rather than being critical of your actions as doctors, legal processes will often validate your actions and your practices. However, being candid with you, there are other occasions when that will not be the outcome, and the result will be a much more critical consideration. And as I've said on a number of occasions, I don't want to suggest that in those circumstances, the immediate reaction that you will have will be anything other than one of stress to what has happened. But perhaps standing back from the immediacy of a particular situation, one might be able to see good coming out of such an engagement. I want to suggest that your engagement with such legal processes can result in positive outcomes, one that brings learning, perhaps for you as the individual doctor involved in a particular case, but perhaps more widely for the profession as a whole. In 1948, when Churchill spoke to the House of Commons about a particular matter, he used what have now become famous words of his when he said, those who fail to learn from history are doomed to repeat it. And perhaps those words neatly encapsulate my point tonight, that there is perhaps a good case for involving your interactions with legal processes as an engagement not with a foe, but rather than with a friend, albeit on occasions a critical one. Let me give you one very practical example. Very sadly, in October of 2015, a 36-year-old married woman of a number of matters that were associated with acute epiglottitis. It became apparent at the Coronal inquest held into her death that there was what the coroner described as a dearth of knowledge about that illness, including its symptoms. The coroner wrote to a number of bodies responsible for healthcare in Northern Ireland about the particular case, and in particular, he encouraged those responsible for the training of doctors to improve their teaching about that particular condition when it was found in adults. As doctors, and particularly as surgeons, you quite literally hold the life of your patients in your hands, and the responsibility that you carry is enormous. In some ways, the law, although I accept it may not always feel like it, acts as a form of a quasi-partner with its checks and with its balances, and hopefully by exercising scrutiny leads ultimately to improved clinical practice and therefore better outcomes for all. Let me finish by promoting one forum outside those formal legal processes that I have mentioned, whereby lawyers and doctors can meet together and can share together. It's the Northern Ireland Medicolegal Society. Now, later on, Gary will make available to you any who want it some application forms to join the society. The society meets on 4 occasions each year, and talks are generally given either by lawyers or by doctors on matters of mutual interest. The last 2 talks that I attended were on contaminated blood and one around the very current issue of apology and the duty of candour. We must guard against lawyers and doctors engaging in the dialogue of the deaf. Instead, while each profession has their separate and their important roles to play, what we need to do is we need to foster a culture of understanding and one of respect. And in doing so, hopefully that will ultimately lead to the good and the benefit of all in society. So I hope those general comments are of some assistance in setting some of the context to what others are going to follow on and to say. Thank you.
Thank you very much, Philip. Some interesting points there. Thank you. And now I would like to introduce our second speaker, Mr. Joe Mccrisken. Mr. Mccrisken read law at the University of Ulster and at Queen's University Belfast before being called to the bar of Northern Ireland in 2002. He specialised in criminal law and practice, appearing for both prosecution and defence in the magistrates and Crown Courts. In 2013, he became a deputy district judge, and in 2016, he was sworn in as a coroner for Northern Ireland. Mr. Mccrisken is one of our 3 coroners, and I believe the youngest coroner to be appointed in Northern Ireland. I also believe we have Eric Campton to thank for Joe entering the legal profession, and that, like Judge Gilpin, he enjoys cycling. Judge Gilpin was, however, at pains to point out to me that he considers Joe slower than him. Mr. Mccrisken, we are grateful for you for agreeing to speak to us this evening with regards to coroner's law and the conduction of inquest and the interaction of the surgeon clinician with the coroner service. Thank you, Joe.
Thank you, Gary and Philip. I'll get you back for some of those. It was almost like a best man speech. So these Zoom webinars and Zoom calls can be great levelers. I'm not sure how many delegates we have or who the delegates are, but if any of them have been in a court at an inquest, a witness or as an observer, they've seen me sitting up at the front in a very regal-looking blue gown in a large court. Now they can see me in a fleece, hiding out in my in-laws' conservatory, hiding from my 3 children, whose bedtime it is at the minute. So I commented to Gary and Philip beforehand that they had many more books in the background than I have. And to prove that I am in my in-laws, my mother-in-law just stepped in with a large Belfast Bap and a glass of wine for me. I won't be drinking the wine during this webinar. I'll wait until at least the end. I've been given 15 minutes to do what normally is a 3-hour presentation, so I'm going to skip through it pretty quickly, and I hope to get some questions at the end. And the panel discussions tend to be perhaps we get a bit more detail, or some of you will have more detailed questions at the end. So I'm not sure what experience the delegates have in terms of inquests or being part of inquests or giving statements to inquests. So I'm going to give you a little bit of an introduction first of all for a couple of minutes, and then maybe delve straight into your legal duty, and then some general comments about inquest. Philip's covered quite a lot actually of very general sense about the medical legal aspects of inquests and the purpose of them. But as Gary said, there are 3 full-time coroners in Northern Ireland. There is about to be a 4th, actually, to assist with some of the legacy workload. We also have some county court judges and high court judges helping us out. Judge Gilbert is one of them, with some of the legacy inquests. For the year ending 2019, there were about 17,000 deaths in Northern Ireland in total, and about 4,000 of those are referred to coroners. So it's only about a quarter of all deaths are actually referred to coroners. The other 13,000 or so are registered in death certificates. And I'll come to that a little bit later. I'll just touch on that a little bit later on. But so coroners don't, unlike England and Wales, not every death is referred to a coroner. Out of those 4,000 deaths, about 1,000 of those reported require a post-mortem examination. And of those 1,000 post-mortem examinations, there are about 150 inquests. So some of you who may have already worked this out of the 17,000 or so deaths every year, there are about 100, 150 inquests. So not that many inquests. And if you split that between the 3 coroners, that's about 50 each a year. Now, some of those will be longer than others, but so we don't have really that many inquests. Sometimes the families of the deceased can be are satisfied with a meeting with the coroner, sometimes with a pathologist, and deaths can be registered that way without the need for an inquest. I'm a big advocate of not having court proceedings, not having an inquest unless it's necessary for some of the reasons I'll give in a moment. We had an audience here, I normally ask how many of you medics or surgeons are aware of the law underpinning your obligations to the coroner, and not unusually, not many doctors will actually know that it's the Coroners Northern Ireland Act 1959, made by the old Northern Ireland Assembly. Specifically, it's section 7 of that piece of legislation that carries with it this requirement. And I've deliberately not used any slides, but the requirement really is that every medical practitioner who has reason to believe that the deceased person died in a number of different ways, and I'll just go through those briefly now. So that's the duty is on every medical practitioner, and that can be a surgeon or GP, registrar or SHO, who has reason to believe the deceased person died either directly or indirectly as a result of violence, misadventure, or unfair means, through negligence, misconduct or malpractice, through natural disease or illness, or in such circumstances as may require investigation. So those are the circumstances set out by Section 7 of the legislation. Now, I gave a talk recently to medics in the intensive care unit in the Royal Victoria Hospital, and this was a specific part that I dealt with, particularly in the intensive care setting, where the patient may well have come from another hospital or another setting, and perhaps been arrived in the intensive care unit via ambulance. The duty rests with the medical practitioner to report to a coroner a death that may have occurred in those circumstances. So the duty really is on that medical practitioner. Perhaps it might be a surgeon who's performing surgery, but the patient's been transferred from somewhere else, to look back into the care that the patient has received, perhaps in another setting or another hospital. And because I'm speaking specifically to surgeons here, so for instance, if a patient had been transferred from another hospital in Northern Ireland and you were performing a procedure on that patient and they died, and you had suspicions about the behaviour or care of another medical practitioner, nurse, paramedic, then the duty is on you to report that to a coroner and not to wait on the other medics, nurses or paramedics who are involved. And if you didn't, and I've held inquests where the, if you like, the end doctor, the end medic who reported the death didn't relay those concerns, then you would be open to criticism, in my view, rightly. So it is a serious duty that you, a responsibility that you have under the legislation. In theory, you can be prosecuted for breaching or not complying with that legislation. Nobody ever has, as far as I'm aware. I was speaking to a medical director this morning of the Royal Victoria Hospital, and we're speaking about just this issue and separate case, in fact, involving one of the hyponatremia deaths. I was speaking to police officers, and they were looking at Section 7 of the Coroner's Act as a route to investigate medics. So you should take that responsibility seriously, and you should, after this webinar, all go and Google the 1959 Coroner's Act and read Section 7, in my opinion. Coroners in Northern Ireland. So coroners in Northern Ireland have the widest jurisdiction of any like system in the world. So we can investigate every death, whether the deceased died from natural causes or not. In England and Wales, there's a bar on coroners investigating where natural causes are the cause of death, but coroners here can and do investigate a great variety of deaths. I'm going to flick through some of those now very quickly. So we investigate deaths in prison. If you happen to be involved in the treatment of a prisoner who has died, there will be an inquest. There has to be an inquest, and it must be held with the jury. And that's something you should be aware of from an early stage. So you will have to give your evidence if you've been involved in that person's care and they've died while the prisoner at an inquest, ultimately in front of a jury. We have jurisdiction to hold inquest into stillbirths. That comes from a 2013 Court of Appeal case. And as far as I'm aware, we're the only jurisdiction in the world that can do that in Northern Ireland. You may have spotted, some of you, if you read the Sunday World, I'm not sure that is on the Sunday table of a great many medics, but there's a campaign presently to allow deaths which occur outside Northern Ireland to have inquests inside Northern Ireland. So if you die in Spain, for instance, or somewhere else abroad, and you can't have an inquest in Northern Ireland, it's different to the position in the Republic of Ireland and England and Wales. And that's because of the way the legislation is framed. I'm going to come, I think I'm in the last 10 minutes now, so I'm going to come to the inquest itself. I've assumed that you'll all may know or should know how a death can be reported. There's three ways effectively a death can be reported: by a death certificate, where you have seen and treated the patient, seen and treated. That's the important part to point out. The patient for the condition that they died from. Now, the Coronavirus Act has amended that slightly to give greater powers to medics, but hoping that's going to be rolled back after Christmas. So death certificate's one. The second one is called the Form 14. So that is where you haven't seen and treated the patient, but the reporting medic can suggest a cause of death based upon clinical evidence. And if a coroner accepts that, then there doesn't need to be a post-mortem, and a Form 14 can be used. And the final way is where a post-mortem for a Coronal forensic post-mortem is required. And those are the three ways that death can be registered in Northern Ireland. In terms of the inquest itself, so Philip has posed a question as to whether certain medical legal proceedings are friend or foe to medics. In my view, inquests are more often a friend than a foe. And you might expect me to say that, of course, but as coroners, we have gone out over the last 3 or 4 years and made a real concerted effort to speak to medics, as many medics as possible, as many different settings as possible, to reassure them about inquests. I know, as I have friends who are medics, that it can be frightening to get a request from a coroner or the coroner's office asking for a statement. And most medics will take that request as some sort of accusation that they've done wrong, they may have done wrong. And in almost all cases, that couldn't be further from the truth. In fact, I order statements regularly as a coroner, very often to ensure that I don't have to have an inquest, so that when the post-mortem report becomes available, I also have a number of statements from the treating clinicians. And then what I'll often do is sit down with the family, go through that material, and in a great many cases will decide that there's no need for an inquest and the death can be registered following that meeting. But I need those statements early in order to do that. So a request for a statement is nothing other than a request for information from you about a person's death, and nothing further should be read into that. If you are contacted by the coroner's office and are made an interested person in an inquest, well, then you should get worried, because that means I have a special interest in your actions, but you'll be kept well informed of the reasons for that. Way back in the 1980s, the Broderick Committee, who looked at inquests, set out the grounds of public interest which a coroner's inquest should serve. I'm just going to read through those very briefly now. First of all, an inquest should determine properly the medical cause of a person's death. An inquest can also allay rumours and suspicions about a person's death, and in a hospital setting, an inquest can do that very, very effectively, in my view, much better than an SAI or some internal investigation, because of the way that evidence is tested at an inquest. It's less comfortable, I appreciate that, for medics, an inquest than an SAI, because of the nature of the way that evidence is taken. So I take evidence on oath in the witness box in a formal setting. SAIs, of course, don't do that, but that's why I say that inquests are a much better way to get to the truth than some other processes. Inquests should also draw attention to the existence of circumstances which, if unremedied, would lead to further deaths. So there's an aspect of learning in inquests, and that's why it's crucially important that they happen as quickly as possible. There should be no delay. Delay is just not acceptable when it comes to holding an inquest. So you should not be in a position, no family, no medic, no trust should be in a position where a person dies today and an inquest is held in 4 or 5 years' time. It's just not acceptable. And I'm the first one to say that. The target that we set is to have an inquest within a year of the death. And I think that's reasonable. Sometimes these things might take slightly longer because of the nature of the death or the proceedings, or because civil or criminal proceedings are in the offing, but inquest should happen quickly. And that benefits not just the family, but also those clinicians, nursing staff, witnesses who are involved, who shouldn't have this hanging over them for a prolonged period of time. That just shouldn't happen. Inquest should also, according to the Broderick Committee, advance medical knowledge. And again, having inquests quickly, taking statements quickly, can assist that process, so that we're not having inquests 15 years on from the death, where no one benefits from that. And also to preserve the legal interests of the deceased person's family, heirs, or other interested persons. Now, more often than not, I hold inquests to not to criticise, and I'm talking about hospital where deaths occurred in hospital. More often than not, I hold an inquest not to criticise the medics involved, but to inform the family that good practice has occurred, that their concerns that they perhaps have communicated to me are unfounded, and the families are involved as much as the trust. They need to come into that inquest, listen to the evidence, correct, on a lot of occasions, correct the false assertions that they've had about medical treatment, and then go back out to the community and tell their friends and family and the people who they had commented about medical practice to that they were wrong. And I don't think when Philip used the quote of the coroner, I'm not sure that was me, it might have been Mr. Leckie before me, but on lots of occasions in an inquest, not only have I commented on the good practice, but made sure that the press who are there put that in their story, because I know, and you'll know better than me as surgeons and medics, that the press like nothing better than to criticise medical treatment, to criticise the National Health Service, but that's not what inquests are all about. The medical director I was speaking to this morning said if only he could reassure a lot of his medics about the legal process in terms of inquests, he thinks they would give better evidence. Well, this webinar is part of that process that the coroner service and coroners are undertaking. In terms of the scope of an inquest, I'm going to wrap up in the next couple of minutes here. You'd be glad to know scope of the inquest, really, there are 4 questions an inquest should seek to answer, and there are only 4 questions: who the deceased person was, when did they die, where did they die, and how did they come by their death. And that means effectively the medical cause of death. Now, there will be other issues that that a coroner will look at. An inquest should not and must not provide any opinion on criminal or civil liability. So an inquest should not comment on a medic's civil or criminal liability. And in all of the inquests that I've held over the last 4 years, only on one occasion have I taken the step of referring a doctor to the GMC. On one other occasion, that the surgeon, as it was, self-referred based upon the evidence he'd given at inquest. So that's only 2 occasions out of the probably hundreds of inquests that I've heard. And on both those occasions, at least on the first occasion, the conduct was, so bad that the GMC had to become involved. I know there'll be other speakers today who talk about those GMC processes. I don't know enough about them to comment on them, but it seemed to me that even at inquest, where a number of experts had, a number of very senior medics who provided expert evidence had criticised this junior doctor's actions, which had led to the death of a child, she still wasn't prepared to accept or reflect on her practice, and therefore the only action that I could see was adverse comment by me and referral to the GMC. I don't know what the outcome was. I'm still awaiting that, but that should be the exception rather than the rule. I'm going to close up now by normally at the end of these talks I have some words of wisdom, but in terms of surgeons and medics, take good notes. If you've been along to an inquest and had your notes examined forensically, as they are by barristers and solicitors and coroners, I guarantee you'll take good notes on every other occasion. But you shouldn't have to have that. And I know I sound terribly patronising here, but it will benefit you in the long term if every time you take a note, you imagine a coroner, a patient dying the next day, and a coroner then poring over it with a number of barristers. So thank you very much.
Thank you very much, Joe. Our third speaker probably needs little by way of introduction to most of you. Geoffrey Campbell is a recently retired Truly general surgeon. Until his recent retirement, he was a valued colleague of mine and my immediate predecessor as the ASGBI rep for Northern Ireland, as well as the position of being Mr. John Muirhead's senior registrar, a period he relinquished in my appointment to the Ulster in 2006. Jeff worked in the Ulster for 21 years, and in that time he spent 5 years as regional advisor for surgery and 3 years as head of school and training programme director for higher surgical training in general surgery in Northern Ireland. He subsequently spent a further 5 years on the national ASAC, having responsibility for inspection of training in the Republic of Ireland. Apart from being a really great bloke and probably the most attractive surgeon in Northern Ireland, often being mistaken for young George Clooney. Sorry, I couldn't quite read Jeff's handwriting, and that was Jeff's pen picture that he sent to me. Jeff's a dab hand at homebrew as well as conflict resolution between dog owners in Killynetherwood and Newton Ards. Jeff is going to give his personal experiences of dealing with the GMC. Okay, Jeff, thank you.
Thanks, Gary. I hope you can hear me okay, yeah? I was delighted that Gary asked me. Since I'm in retirement, I don't get out much. I retired in March, but then I realized that nobody gets out much now, so it's good to be able to join you tonight. I thought I would give a quick talk on my experience with the GMC. Gary asked me to speak on some aspect of medical legal work, and I didn't really think I was particularly well qualified to do that. And we batted things around a bit and came up with this idea that it might be helpful for all of you to just go through my experience. It may help some of you if you're in the same position, or if your colleagues are in the same position as I found myself in some years ago. It's not something that you will hear people talk very much about. I think there are two reasons for that. One, I think the whole of experience is quite stressful and people don't like to speak about it. And also because I think there's an element of embarrassment among the medical profession that they have been referred to the GMC and people don't like to broadcast that. I hope none of you find yourself in this position, but sadly, I fear many of you will. The figure that I had in my mind from a talk I heard once was that in a colorectal practice, 1 in 4 consultants can expect to be referred to the GMC in their working lifetime. And certainly from the period 1992 to 2012, the number of referrals to the GMC increased 8-fold, and the number of hearings also increased by a factor of 5. So could I have the next slide, please? I don't have a button to push. So what I thought I would do would be to review the case, talk about my contact with the GMC, a little bit about the impact it had on me and what I learned from the process. So could we have the next slide? Next slide, yeah. So the case is that of a 42-year-old male who was referred with, married, 2 children, referred with coccygeal pain, testicular pain, and bleeding PR. He DNA'd for his first appointment, he chose to go on holiday. He then reappeared, was referred for flexible sigmoidoscopy and found to have a rectal tumor, which was staged by CT scan as T4N1 and referred for long course chemoradiotherapy and then surgery planned after that. Could have the next slide, please? So the plan had been for a low anterior resection, but intraoperative findings weren't favorable, and that was converted to an abdominal perineal. And while the tumor was reported staged on the pathological specimen as a T3N0, biopsies from the pelvic side wall were positive for tumor, and therefore it was an R1 resection. I should say that I did not do the operation. He was not my patient at this point, and he was referred on for adjuvant chemotherapy after his surgery. And he did reasonably well for about a year, but then he was found to have a rising CEA, and he happened to get admitted with a small bowel obstruction under the care of the surgeon who had operated on him. And CT scanning at that time showed a pelvic mass, which was thought to be tumor recurrence, and pulmonary nodules, which were thought to be metastatic disease. And he was referred on for palliative chemotherapy. Could I have the next slide, please? So 4 weeks after his initial admission with a small bowel obstruction, he was readmitted, having had 1 course of chemotherapy. At this stage, he was immunosuppressed, he was neutropenic, and I can recall there being difficult ward rounds. You'll all be familiar with the situation. He was lying in a bed unwell. His wife didn't leave his side. She was there at 8 o'clock in the morning for the ward round. She was there at 6 o'clock in the evening when we did a ward round. And he and his wife placed great emphasis on this chemotherapy that he was having. And I can remember having difficult conversations with him, explaining that if we operated on him, he would not be able to have his chemotherapy. And it would delay things for a number of weeks. And they were adamant that he needed to have his chemotherapy. If he didn't, he was going to die. And it was just all a very difficult situation, which was understandable given the terrible situation that they as a family found themselves in. So he failed to settle conservatively on this occasion, and we took him to theatre. I did it with a consultant colleague and an experienced senior registrar. And and we found a large tumor mass in the pelvis. It clearly wasn't resectable. We took the small bowel off it, did an anastomosis, and he discharged himself 5 days post-op against medical advice. He was reviewed at the oncology outpatient clinic where he presented for consideration of ongoing chemotherapy and was noted to have a swelling in his perineum at the site of his APR scar. And the consultant oncologist asked me to see him. I left my clinic, went round to the McDermott unit, saw him with my colleague. We both agreed he had a perineal hernia that he should not have any treatment for at this time, since he was about to commence his chemotherapy again, or have ongoing chemotherapy. So, could have the next slide, please? So he recommenced chemotherapy, and 6 weeks after the outpatient review, presented to the A&E department with a discharging perineal abscess, which was treated with incision and drainage and was noted to have tumor at the base. This was dressed for 6 months by the district nurses. On one occasion, my consultant colleague noted that at review, there was dressing gauze in the wound, and it never really healed, as you might imagine. He failed to respond to the chemotherapy, which was discontinued. And 6 months later, in early July, he unfortunately passed away. So if I could have the next slide. Knowing that there is a complaint coming here, you might want to have just a few minutes to think about what you think might be the issues that were raised. And I'll just go through the process now. So next slide, please. The first contact that I had from the GMC was in Barcelona. I was on holiday. I had gone on holiday with my family. It was a difficult time. My daughter had brought the boyfriend, who's now her husband. But you know, holidays with boyfriends are never a lot of fun, as some of you might discover. We'd had an electrical storm pass through the place where we were staying, and it had taken out the electricity supply and the water supply to the villa that we were in. So we decided to leave and go to Barcelona. I booked into a hotel that I'd stayed in previously. So when I walked into the hotel, my iPhone connected to the hotel Wi-Fi. And I realized I had an email from the GMC. Now, usually these things are updates and things, and I tend to ignore them, you know, the same way as you ignore the updates from the ASGBI and the College of Surgeons. You just ignore it. But I happened to read this one, and it was telling me that I had failed to respond to a letter that had been sent to me, and that failing to do so was a notifiable offence. And I was a bit confused about this. So I phoned the GMC. My initial reaction was that there must be some mistake. It couldn't be me. There was another W. Campbell who worked in the hospital at the time. It had to be him, because I had no recollection of the name of the patient that they gave me. I couldn't recall it at all. But the GMC wasn't for people like for me. It was for people like Harold Shipman and Ian Patterson. My view was that I had worked hard. I was up to date, good results, good relationships with patients and staff, and therefore there had to be a mistake. It couldn't have possibly been me. But the person reassured me that it was me. So what I did next was, next slide, please. Made a few phone calls from the car park in Barcelona airport at about 7 o'clock at night to my colleague at home, and asking him to look up the records to try and refresh my memory as to what was who the patient was. I came home and discovered that the letter that had was sent to me, now the letter was sent on the 30th of August and I had gone on holiday on the 31st. And therefore I had missed the letter. That letter, a previous president of the association, I heard give a talk on such matters many years ago, referred it to as Dear Guilty Bastard letter. And that is pretty much the tone that comes across in the letter. You do feel very much that you're being accused and found guilty before anything has been heard. So I contacted the MDU and did as the GMC asked you to do, which is to inform them of all your other places of employment, because they then contact those places to determine if there are any outstanding issues with your practice in whichever arena it is. So I did some work in the Ulster Independent Clinic, so they were contacted. I was still an educational supervisor and a clinical supervisor for trainees. So NIMTA were contacted, where I had worked for many years. And the people in these places knew me, and they weren't told the nature of the case. They were simply told or asked, were there any issues with my practice? Because I had been referred to the GMC. I then prepared a report answering as best I could the allegations. On the day that the wife of the unfortunate gentleman referred me to the GMC, she also wrote a letter of complaint to the trust, telling them that she was going to take out legal proceedings against me. And she also wrote to the then Minister for Health here, Edwin Poots, informing him that I was negligent and an incompetent surgeon. She did this, she informed me and other people who had inquired of her on the advice of the patient and client counsel, and I'll come back to that at a later time. But the elements that she complained about were that I had left a swab in his abdominal cavity at the time of the laparotomy, which had resulted in a pelvic abscess, which I then misdiagnosed as a hernia. And as a consequence of this, her husband was prevented from having life-saving chemotherapy. And on top of that, I was rude and arrogant. So I spoke then with my advisor from the Medical Defence Union, and we prepared the report. And he assured me that this would not be a great problem. With regard to the complaints, we had a swab count at the time of the surgery. We had radiological evidence in form of CT scanning afterwards that there was no evidence of a swab in the abdomen. We had evidence on a CT scan that there was no sign of an abscess when I diagnosed him as having a perineal hernia. So he felt very much that this was a fairly clear-cut thing and this would not really be an issue. So could I have the next slide, please? So what the GMC process is that they gather the evidence, and a panel of two meet and look at the evidence that they have obtained the complaint from in this case the wife of the deceased, my report, and any other reports from any other arenas where I was working. And the reassuring thing from a medical point of view is that at that point, 80% of the cases are dismissed. They go no further. And the test that they apply is this thing called the realistic progress test, which if they think there's a chance that the realistic progress test is met, you will then be referred to appear before a fitness to practice panel. And they do have the opportunity, if they feel that your practice is particularly poor, of immediate restriction of your practice. But generally, the majority of cases will be dismissed, but 20% will go on towards to a fitness to practice panel. Could I have the next slide, please? So the realistic progress test, I'll let you read it there. This is from the GMC, as to what they say. And you know, it is very reassuring that the cases that progress, they want to be fairly certain that there will be a problem with the medical practitioner's practice. They don't want to send cases forward that are not going to result in an outcome, essentially. And this would seem to be the case, that of the 20% of cases that go through, 80% of those will result in some sanction to the individual who has been referred. But as I say, my MDU liaison was fairly confident that this would not come to very much. So I submitted my report and waited for to get the word that everything would be okay. But I didn't hear anything for some weeks. Could the next slide, please? So I didn't hear anything. I contacted the MDU and he made a few inquiries, and he said, well, it's not quite as straightforward as I had hoped. They've asked for an expert witness report. And if any of you have done any medical legal work at all, in my opinion, when you get down to getting an expert witness report, you're very much in the lap of the gods, because some of the expert witness reports that I have seen have been less than impressive. So I was beginning to get quite anxious by this stage. I was waiting for the outcome of the initial inquiry to see whether I would proceed to a fitness to practice hearing. So in my work, I think I became, some of my colleagues might be able to say this better than me, but I felt I was becoming risk averse. I started to practice defensive medicine a bit more. I didn't want to have any further complaints. I didn't want to have any, so if someone felt that they wanted to have a CT scan, I would have erred on the side of caution. I didn't want to miss things. I just felt that my practice was changed slightly. And it also, I think, impacted on me outside of work with my family. I was probably a bit anxious at home. I spent many of an evening trawling through things on the internet, looking for things to support the approach that I had taken. And I was probably anxious and perhaps even bordering on mild depression, I would imagine. But anyway, so the process went on. And finally, after 7 months, at the behest of the MDUs, I contacted the MDU again and said, can you please find out something? He got a response from the panel. Could I have the next slide, please? So fortunately, as you can read there, everything seemed to go very well. The expert witness report had said that I wasn't at fault. They relayed that in the report. The slightly worrying thing from reading it is that had I left a swab in, or had I misdiagnosed a hernia, or that would have been considered to be a significant event that would have resulted in an action on my registration. But the report concluded that Mr. Campbell's treatment of Mr. did not fall below that to be expected of a competent surgeon. So I was competent. And that was, I thought, very good. Except, next slide. This is the last line of the report. There is no signature after this. This did not come from anybody. I don't know who this came from. The last line of the report reads, the realistic progress test is not met and the case will be concluded. Not that I was innocent. To me, that is, we couldn't find enough evidence to progress. Doesn't mean to say there wasn't a problem. So rather than say I had not been at fault, they've said we couldn't find enough evidence to proceed. And when I discussed this with the MDU, their opinion was that this was akin to Scottish law where there is an outcome which is not proven, which I'm sure two previous speakers may well know more about than I do. But I was not happy with this. But the advice was, don't pursue it. You're not going to win against the GMC. So, to the next slide, please. So at this point, I received my first phone call from the medical director, who congratulated me and said, that's great, everything's sorted out. And the but was, you now need to be careful because there's now a file on you at the GMC. And if there's a further problem, they're more likely to take action than not. So there was, and then having had this report sent to her from the GMC, she came back to say that she was going to sue us or sue me for my negligence. But because she wasn't able to obtain legal aid, she would be representing herself. And that then subsequently fizzled out. And at the end of a further period, she then put in a further complaint against me to the trust. So she referred me to the GMC, threatened litigation, and then finally put in a complaint. So I was unhappy with the idea that the patient and client counsel had advised her to refer me. And so I contacted the patient and client counsel. The next slide, please. So when I contacted the patient and client counsel, they assured me that this was not what they had in actual effect said to her. But they gave everyone who contacted them a range of options, starting with complaint to the trust, and the final option is referral to the GMC. And it's up to the patient or the patient's relative to choose which course of action they choose to route to go down. I said, do you make any attempt to determine if there is any truth in any of the things that they state? And they replied, no, that was not their position. They were there simply to support the family, and therefore they did not see any need to change their policies. So the impact that this had on me, our own chief medical officer recently, when the neurology inquiry was just kicking off, came out with the statement that he was diminished as a doctor by the actions of someone else. Well, I felt diminished as a doctor by the actions that had been imposed on me. I certainly had a degree of anxiety at work for a period of time, as you might imagine. As I say, I think I practiced slightly more defensive medicine. I was wary of contact with patients. If I could avoid some things, I did do so. And certainly there was a significant loss of enjoyment at work. I was demoralized by the process. And I wouldn't say that it contributed to my decision to retire when I did, but it was an ongoing issue throughout the remainder of my working life that I had this referral. When I, as the report said, had been competent in my practice, and at the same time, I was expected to soak up these complaints and take no action against the party that had made them. And Northern Ireland is a small place. Surgery is a small community. I live in a small town, and as Philip mentioned earlier, we are worried about how we are perceived. And I certainly didn't want Mary Louise Connolly waiting for me coming out of the Ulster Hospital some night, or to appear on the Stephen Nolan show, or have my name bandied about. And so there is this, many of us take pride in our work, and there is this undermining of your position and a degree of humiliation. I must say I felt anger towards the system. I certainly didn't think it was fair, and I still don't think it's fair. So just what did I learn from this? Give the final slide, please. Well, I learned to think to avoid confrontation a bit better. I learned to bite my lip. I learned to chew my lip off on occasions. I subsequently discovered that I wasn't alone in having gone through a process like this. I discovered that several colleagues and several surgeons that I had the utmost respect for in Northern Ireland had been through the same process, but it wasn't widely known. I discovered that my immediate colleagues were very important in supporting me through it. And I am very grateful to them for that, and also to my family. My wife was a GP, so she had an understanding of the significance of being referred to the GMC. And so I was grateful to my colleagues and family for their support, and that support was very important. I discovered that there wasn't really any other support from any other body. I certainly didn't get a huge amount. I didn't get officially from the trust. There didn't appear to be support from any of the other organizations that I was aware of. And I think that is something that we should maybe take into account, that this is a very stressful situation to find yourself in. And it would be good to have some sort of formal supportive mechanism established within a trust, or perhaps the ASGBI might think that there's something that could be done in that regard. And I suppose the final point, what I would say, is that it didn't mean I was a bad doctor. Now, I hope none of you find yourself in this situation. And if you do, I would reiterate that. It doesn't mean that you are a bad doctor. You might be a bad doctor, in which case I would not support you in your position, because I don't think there's any position, any place in our profession for people who do not commit and try and do their best for patients. But if it does happen to you, just bear in mind, it doesn't mean that you're a bad doctor. And I'll finish there. Thank you.
Jeff, thank you very much for that heartfelt and honest presentation. I think it certainly is raising the questions are coming in thick and fast, and I think there'll be some more discussion on that in the panel. But I think just before we get to the panel discussion, we have our last presentation. Our final presentation tonight is being delivered by Professor Gordon Carlson. Professor Carlson is a consultant general and colorectal surgeon, honorary professor of surgery and clinical lead for the National Intestinal Failure Unit at Salford Royal NHS Foundation Trust. He's written over 180 academic papers and book chapters and has attracted over £5 million in research grant income. He's been awarded numerous visiting professorships at British, North American and Scandinavian universities. And he currently chairs the ASGBI Medicolegal Committee, for which he co-wrote the ASGBI and Royal College's position paper on gross medical negligence manslaughter in April 2018. His extensive experience of expert medical legal practice, as well as leading an ASGBI collaboration with NHS Resolution to provide educational initiatives aimed at reducing the impact of civil litigation in medical practice. He was awarded a CBE recently in the Queen's 2020 New Year's Honours List for recognition of his national and international contributions to general surgery, and in particular to intestinal failure surgery. And Gordon tells me that someday he hopes to get the Buckingham Palace to collect it if the COVID pandemic restrictions allow. Gordon, I'm very grateful for you agreeing to chat to us and give this presentation tonight. Thank you.
Well, thank you, Gary, and I'd like to thank particularly our colleagues in Northern Ireland for asking me to come and talk to you in this webinar after the Lord Mayor's show, as they say. So I'm going to try and wrap this up by looking specifically at some practical aspects of surgical practice with a medico-legal flavour. Next slide, please, then, Vicky. If you could move on. So a few very quick disclosures. As you've heard, I have a number of unpaid roles, specifically in relation to the ASGBI, but also as a director of ASGBI's indemnification company, SIS. I've been involved in collaboration with NHS Resolution, but I'm also, I have a medico-legal practice for which I am paid. I've, for the purposes of clarity, set out the relative breakdown of my work, which is about 55% instruction by claimant solicitors, 35% instruction by defendant solicitors, and 10% joint. I've delivered an invited lecture for the Association of Personal Injury Lawyers last year, for which I was paid, and I've also given lectures for which I've not been paid for claimant and defendant solicitors, to try and explain to our colleagues in the law what things like sepsis and anastomotic leakage mean, because often there is, just as there's a relatively low level of understanding sometimes in the medical profession about how the law works, there's often very poor understanding in the legal profession about what are some of the common issues we deal with every day, and hopefully better understanding between both medical and legal professions will help us serve the needs of our own professions better. Next slide, please. And I want to say a very quick word about SIS. I have to, partly because I'm the director of SIS as chairman of the Medico-Legal Committee for ASGBI. But for those of you who are not aware of what SIS is, it's ASGBI's own indemnification scheme. If you like, it's ASGBI's version of the MDU. It's part of a professional insurance stable now owned by Gallagher and underwritten by a large company. But most importantly, it's by and only for general surgeons. So members of the SIS benefit because it only covers surgeons in general surgical practice, and therefore we are not subject to the very large lawsuits, and therefore the amount of money required to indemnify people who practice neurosurgery and obstetrics, where there are often claims running into tens of millions of pounds. There is contractual cover for GMC and disciplinary issues, whereas with some of the other schemes, notably the MDU, for example, the cover, for example, that you heard Jeffrey get was discretionary. And therefore, if the MDU feel perhaps one has been particularly bad, and these are the issues in particular, as I understand it, in relation to cases like Patterson, there is the opportunity for some indemnifiers to actually withdraw cover for those issues. And I put the web address at the bottom of this slide for those of you who might be interested in SIS and looking further. But if we can move on, please, next slide. So what I want to briefly cover this evening are what civil claims are. In other words, the anatomy of a claim. Why do claims arise? What do we mean by duty of care? What is a breach of duty and where is liability? And how does that map onto causation? And finally, injury and quantum. Those are issues which lawyers use all the time, because they, if you like, reflect the various elements of a civil claim. And finally, and I want to spend quite a bit of time talking about Montgomery, which Philip has also already mentioned, and its implications for clinical practice. Next slide, please. So, it's not actually that easy to pursue a civil claim to a successful conclusion. Certainly as a practicing surgeon, one's inclined to believe that if there's an adverse event, there is a claim and claimants are paid out. Certainly claimants see it from a very different point of view entirely. To succeed, the claimant has got to convince the judge that the defendant owed the claimant a duty of care, and that the defendant breached that duty of care, and that that breach caused or at least materially contributed to some form of quantifiable injury or damage, and that that damage was reasonably foreseeable during that process. So there's a number of steps that have to be followed, and all of those have to be followed successfully for a claim to succeed. In addition, the standard of proof in civil cases is much lower than in criminal cases. So in other words, this is not a question of beyond reasonable doubt. All that the claimant has to do, apart from get through those 4 steps, is to show that these things happened on a balance of probability. And the phrase that is often used in civil proceedings is whether it was more likely than not, particularly as far as the breach of duty is concerned. Next slide, please. Duty of care is usually straightforward. It's not always straightforward, and there are 1 or 2 things which are of interest, which I'll talk about in a minute. It has been suggested that the medical practitioner is the subject of the claim. In fact, this is almost never the case, at least in UK law. Usually, as a doctor working in a hospital, it's your employer, it's the hospital trust that owes the duty of care, not the doctor themselves, although that duty of care is, if you like, exercised by the doctor as an employee of that hospital trust. Duty of care is often straightforward, but it's not entirely straightforward. There's a very famous case, as I understand it, where it was alleged that a drug dealer owed a duty of care when providing heroin to a drug addict, which resulted in the drug addict's death. And that one went through the courts and caused a lot of soul searching. And as I understand it, it was eventually held that the drug dealer did not owe a duty of care to the drug addict. It's remarkable sometimes how finely these things are looked at. But in the context of civil litigation, I think it's important to recognise that just because you have not seen the patient does not mean there was not a duty of care. The duty of care actually starts before the patient was seen. So, for example, if a patient has been referred to your hospital and that referral has been accepted by the organisation, there was a duty of care, and that duty of care is enshrined in the Health and Social Care Act 2012. That duty may include provision of treatment for the patient's condition within a reasonable time frame, that time frame being set out in national targets, the so-called RTT, that our managers get very excited about, the referral to treatment time. And local policies and standard operating procedures may be very important in that, and certainly can be called into evidence should a claim proceed. And you might think, well, what's that got to do with me? Well, it may have something to do with you if a patient is referred with a hernia and you fail to provide treatment for that hernia within a time frame set out as reasonable in the Health and Social Care Act. And that patient then turns up as an emergency with strangulation and requires a bowel resection. So the issue here is that you need to be aware that there is a duty of care on the part of the organisation enshrined in legislation. And we have to make sure that that duty of care is delivered. If it isn't delivered, then the organisation may ultimately be on the end of civil litigation if harm results from an alleged breach of that duty. Next slide, please. So as I said, breach of duty is usually, duty of care is usually straightforward. It's usually the hospital. On the other hand, the breach of duty is usually the issue that experts spend most of their time arguing about when claims proceed. The concept of a breach of that duty is central to clinical negligence claims, and it can be quite difficult to determine. There are 2 legal tests, one of which you've already heard from Philip this evening, and that's the Bolam test. And the Bolam test, which was set out originally in 1957, is that a health professional is not negligent if they act in accordance with a practice accepted at that time as proper by a responsible body of medical opinion. The important thing here is actually the last bit, I think. In other words, it doesn't have to be a practice that every single practitioner in that specialty agrees with. There is often a difference of opinion within a specialty, but as long as it's a respectable opinion that can be supported, usually in writing, by a paper or book chapters. In other words, as long as there's a group of practitioners which may differ, that can still be defended. The next test is the Biletho test, and Biletho really stemmed from an appeal made against a judgment based on Bolam. Basically, what Biletho means is that the court can take a position that actually, if the body of opinion used to support a judgment was unreasonable, a judge can reject it. In other words, if an expert opinion is held by the judge to be illogical, then it cannot be used to support Bolam. So there is discretion for the courts to look at an expert opinion and say, yes, maybe a group of practitioners would have done something different, but actually within the context of this claim, it doesn't make any sense at all, and therefore can reject it. Next slide, please. So I think a really important point on breach of duty and causation is that the standard of care that we're talking about does not have to be an ivory tower specialist, the best medical practitioner in the world. It simply has to be that of an ordinarily competent practitioner working at that level of seniority and practicing in that field. In other words, we're not expecting a houseman or a registrar who's asked to see a patient in the middle of the night who is unwell to make a decision that a experienced senior clinician would have made. But it is expected that they would exercise the standard of care to be anticipated of someone with that level of experience. This has implications for working outside specialties. For example, if a colorectal surgeon were to undertake a hysterectomy, and that was to result in a serious complication, for example, injury to the vagina or injury to the bladder base, the level of care that will be expected of a colorectal surgeon undertaking the hysterectomy as part of a bowel resection would be that of an ordinarily competent gynecologist practicing in that field at the time. And of course, vice versa, when gynecologists might be undertaking surgery on the bowel. Next slide, please. So how these issues are often discussed in terms of civil litigation is to say that in practice, no reasonably competent medical practitioner would have done or have failed to do the issue in question. And the causation that flows from that is but for that act or but for the failure to do something, the following harm would, on the balance of probabilities, in other words, more likely than not, have been avoided. And that sets it out really in very simple black and white terms, whereas in fact, as I've said earlier, there's often a lot of argument about what a reasonably competent medical practitioner would have done and whether or not the harm would have, on balance of probabilities, have been avoided in any event. And that's often where our colleagues in the law spend a lot of time. Next slide, please. I think it is important to look at standards here and for people to be aware of standards. You've already heard from Philip again about the amount of weight that our colleagues in the legal profession will place on published opinion from responsible medical bodies. And there are a lot of these. There's the GMC, I've shown here an important one from NICE. There are any number of bodies, including the Royal Colleges, ASGBI, who have produced guidelines on managing any number of different medical issues. They carry a lot of weight in law for the reasons I've just outlined. They reflect the opinion of a professional body and therefore a responsible body of professional opinion. That does not mean that one should rigidly stick to those guidelines, but you should certainly be prepared to defend working outside them and document why a standard or a guideline is not being followed. If you don't do that, then you can expect to, I think justifiably, be given quite a hard time if a claim arises from your actions. Next slide, please. Informed consent is important, and it's a complex issue. It has been and it continues to be very controversial. We have a duty of care with regard to consent. And actually, if you look at the breakdown of claims, an NHS resolution did this for ASGBI a couple of years ago, what is interesting is that allegations of breach of duty with regard to informed consent is actually usually not the dominant issue. It's very rarely the only issue which comes into play in a civil litigation, but there is usually another breach of duty. In other words, the claimant will say, if I'd been told I would not have chosen to proceed with that treatment, and then, by the way, there was a breach of duty in the delivery of the treatment itself as well. To be valid, consent has to be voluntary. It has to be informed, and the person giving the consent ordinarily has to have the capacity to do so under normal circumstances. Obviously, there are other specific circumstances where patients may lack capacity, and we're not going to have time to talk about those today. But the issue of duty of care in consent has changed in the last few years, and I think this is important. Originally, the duty of care of consent was the same in terms of the Bolam principle. In other words, if a responsible body of surgical opinion was that it was not appropriate necessarily to mention some issue during informed consent, then that was usually regarded as the end of the matter. And actually there was a very well recognized challenge to this in the law in a case relating to Sidaway, in which again the importance of Bolam was affirmed. So as recently as 1985, Bolam was still king as far as consent was concerned. That was overturned in 2015 by Montgomery, as we'll talk about in a minute. Next slide, please. The GMC take a very clear view on consent, and their view is that it's important that all reasonable treatment options are discussed, including no treatment at all for patients. The importance of Bolam versus Montgomery stems from the patient's view of what is important to them, and I'll talk about that in a second. But as recently as 2004, there were beginnings of a movement, as far as I can see, in the judiciary to reflect a greater public desire for autonomy. In other words, a paternalistic view about what doctors felt was in their best interests was not appropriate to the times we're living in now. Chester and Afshar in 2004 held that a surgeon had a duty to warn their patient about any small but possible adverse consequence of treatment, particularly surgery, where there was a well-regarded and well-established risk of injury if it was, it should say serious rather than serous. But in other words, if there was likely to be a serious complication, even if that likelihood was small, if it was felt to be something that a patient would need to know, then the surgeon had a duty of care to warn their patient. Next slide, please. And because of the reliance on Bolam, a bit of a cottage industry grew up until fairly recently. Here, a company who have worked with Royal Colleges, with the ASGBI, produced these really very good patient information leaflets designed to support the process of consent. And the issue here is that based on Bolam, therefore, you would be compliant with Bolam if you advised your patient of risks according to the actions of a responsible body of medical opinion. In other words, here, this leaflet is endorsed by 2 Royal Colleges and the ASGBI, and therefore the idea behind this process is that if you give your patient this consent form, in this case for open inguinal hernia repair, and the patient reads the form and you can confirm the patient has received it and understood it, you're out of the woods as far as consent is concerned. And unfortunately, that is no longer true because of Montgomery, as I'll explain in a minute. The idea that the patient's been given a body of information that a responsible body of medical practitioners would support is no longer enough to get you off the hook on informed consent. Next slide, please. So what's Montgomery about? For those of you who are not familiar with Montgomery, this is Nadine Montgomery. Nadine Montgomery's son was born with cerebral palsy as a result of shoulder dystocia. Nadine is a very petite lady. She knew she was in a higher risk group for shoulder dystocia because she's petite and had a big baby. She had already raised concerns about having a cesarean section as opposed to vaginal delivery, but she was not warned about this, nor was she offered a cesarean section. The obstetrician felt that a cesarean section was not in her best interests because the risk of her child being born with cerebral palsy was only about 1 in 1,000. But a child was born with cerebral palsy and she brought a claim for negligence. Her argument was that she was not given the opportunity on a personal basis to evaluate the risks and benefits of those 2 options. And had she done so, she would have opted to have a cesarean section. And the claim was dismissed. And the reason for the dismissal initially was on the basis of bolum. In other words, it was argued that a responsible body of obstetricians would not have discussed the possibility of cesarean section with her and offered her a cesarean section. And in fact, the case failed, the appeal failed, but finally it was brought to the Supreme Court and it was overturned, that judgment, in 2014. Next slide, please. So the consequences of Montgomery is that consent since 2015, and actually my understanding of the judgment, and it may well be that Philip can elaborate further on this, but my understanding of the judgment is that the judgment does not apply just from 2015 onwards, that in fact the law has always been that for consent it is not based on bolum, that consent should be patient focused and not paternalistic, that a doctor is under a duty to take reasonable care to ensure that their patient is aware of any material risks involved in any recommended treatment and any reasonable alternative. In fact, the judgment goes on to define materiality, and this is important. Materiality for the purposes of consent means whether a reasonable person in the patient's position would be likely to attach significance to that risk, or the doctor is or should be reasonably aware that that particular patient would be likely to attach significance to it. In other words, what it means is it requires doctors obtaining informed consent actually to talk to their patient as an individual and find out actually what matters most to them when discussing treatment options. Next slide, please. So in summary, I think civil claims are unavoidable, and I think one has to accept that this is part of the architecture of practicing medicine, and not take them necessarily personally. I know that's hard, but I think we have to accept that there are a lot of claims which fail. Claims will be brought for all sorts of reasons, just as the GMC referral you heard from Jeffrey Campbell. One can only conclude, having heard what he's just described, that there are all sorts of things going in the background, including a huge amount of grief and potentially misunderstanding. Certainly civil claims are brought for a variety of reasons, and not the least, I'm afraid, financial reasons. If you have clear contemporaneous documentation of your interaction with your patient, you will greatly help the process of defence. There is almost always a duty of care. The consent and the breach of duty are key issues in civil claims. You should be aware of the limitations of what you can and should be doing. If you want to keep out of trouble, you need to be aware of where professional standards and guidelines exist in relation to your own practice. Keep up to date with them, but don't be frightened to deviate from them if that's required in an individual case, provided you can document the reasons. You need to be aware when you're treating patients with, would a responsible body of opinion support the course of action that you're following? But bear in mind the standards that are expected of us are not of the world's best surgeon. They are those of a reasonably or ordinarily competent practitioner working at that level in that field. And finally, I believe we don't need to fear Montgomery. It certainly takes more time to act according to Montgomery, but I think it potentially makes us better doctors. It's actually much easier to sit down with a patient when discussing treatments and to try and find out very early what it is that the patient wants on what is most important to them and actually document that during that process. In doing so, I think your practice will be more patient focused and it will make us easier to keep out of trouble. And I think at that point I'll stop and hopefully we can now take a few questions. Thank you.
Thank you very much, Gordon, and to all the presenters for giving us certainly a lot of food for thought. There's a few questions have come in and I will communicate them to the panel, but I think I would like to start just particularly to Gordon and to the whole panel. We're fortunate enough that Neil Welsh, Vice President of ASGBI, has joined us, and I hope Neil will contribute to the panel discussion as well. But I think particularly to Neil, Gordon, and to Jeff, who's recently retired, do you as a group think that Montgomery has made your life as a surgeon more difficult, or has it in some ways made it easier?
Well, I'll take that first, if I may, because it follows on from what I've said. I think it has been certainly has represented a greater consumer of time in talking to my patients. I don't think there's any question about that. But actually, I think if you take some scenarios, it makes life much easier. So take the scenario of an elderly and slightly frail patient who presents in a 2-week wait clinic with large bowel symptoms, which may or may not be appropriate to investigate. These are, issues that colorectal surgeons certainly come across literally every day. To start your discussion with that patient, trying to find out what they want, what matters to them, what they're prepared to accept in the way of investigations and treatment at the outset, actually makes life so much easier when discussing patients' preferences and treatment, and then obtaining consent to move forward with them. So as I said, I don't think it does make life harder. I think it makes it actually easier, provided we do it properly and document it. Unfortunately, given a very hard-pressed NHS, it just takes more time.
Okay, thank you very much.
If I can come in there, it doesn't make
Certainly,
it better
Neil.
or worse, it just makes it different.
Well,
Thank you.
well, if you want a third opinion, I think it makes it worse. Because I think that if you look at Gordon's penultimate slide where he had the definition of what was required, we're expected to actually be able to mind read and know what a patient would want, and we don't, and we can't. So I actually think that Montgomery makes things much worse.
Can I just
worse? It makes it worse.
Can I just challenge that? I don't think we are expected to mind read. I think we're expected to talk to people and document those discussions. There is the potential, of course, that a patient could always come back and say, yes, but in my view of these issues, certainly over the last 2 or 3 years, where those issues have come up in court, courts have been extremely sympathetic where there is a clearly documented discussion which clearly sets out the nature of a discussion with a patient and what was important to them.
Well, I would say could we look at your slide, the penultimate slide where the definition is there?
If Vicky can go back to that, I'm very happy to do that. That one.
Yeah.
Yeah.
So a doctor should reasonably be aware that the particular patient would be likely to attach significance to.
Yes.
How do we do that? How do I know what you would have? You may not give me the information, you may not talk things through with me, but yet I can still be criticized for not giving you the information that you would have wanted.
Well, of course you could, and I guess if a matter like that went to court, what the claimant would then say is that you should reasonably have been aware that, for example, I was the European crochet champion, and that my ring finger on that hand was particularly important to me because of the particular crochet technique I used. I suppose the argument that you would advance was, I asked you what was important to you, what you did in your life, and why this treatment, how it might affect you, what you would want in relation to that. You never brought that up. I genuinely believe that I don't think courts expect doctors to be mind readers, but they do expect doctors to talk to their patients and find out what's important. And
okay, and document it. Thank you. And I think just changing the tack slightly, I have a question in from Mark Taylor, who and there's a few comments coming in thanking Jeff for his honest, basically taking us through the what clearly is an extremely traumatic and distressing process. But what Mark was asking, mainly for Philip and Joe, was that he thanked Jeff for sharing what happened to him and the terminology used in the final report from the GMC. And can he ask Philip and Joe how we can see duty of candour working in Northern Ireland when there is a perception of anything but that, but anything but a just culture with regards to medics in the province. Basically, I think what Mark is asking is that, we are wanting to promote duty of candour, but there is a perception of feeling in the medical profession that doesn't exist in practice.
I'll have a go at that, and then Joe might want to say something. I suppose duty of candour arising out of the O'Hara inquiry is obviously a very current and topical issue, and neither Joe or I, because of the possibility that it might be legislated for, can really comment on any of the specifics around that. I hope what I had tried to share earlier was that the various legal processes that exist in Northern Ireland are not out to get doctors, and therefore, while undoubtedly there will always need to be areas of reform and improvement, there is no underlying culture that doctors are automatically assumed to be guilty. I appreciate what Jeff says about his personal experiences, but in the general legal process that I have outlined, that is not the situation. And as Gordon outlined, in a civil context, the onus very much remains on the plaintiff or the claimant to prove their case. So in one sense, the duty of candour shouldn't necessarily bring about any particular element of fear. My understanding of the main concern of medics arising out of the O'Hara recommendations is the criminal sanction that is suggested that might be imposed in relation to failure to comply with it. That is the very type of matter that merits a proper debate. When I had mentioned earlier the Medicolegal Society, that is the type of forum where good debate about that sort of issue, and for example, the appropriate form of sanction, should take place. But ultimately, that will be an issue of legislation. And so engagement between bodies such as yourselves and the political authorities is perhaps where proper discussion should take place.
Thank you. I don't know if Joe wants to. No.
I think he needs to unmute.
I think with that, he's maybe on mute. With regards to that, and something similar along the lines of maybe extending, with regards to Montgomery, Scott McCain, who has a significant interest in the whole issue of informed consent, he has put that Montgomery goes far beyond a reasonable patient, in inverted commas, and in his opinion, the definition of subjective patient consent, and he was wondering if anyone had any thoughts on that. That basically that we are almost, and I think Jeff did allude to that, and I know Gordon came back on that about that sometimes we feel that it's more than the reasonable patient, particularly when things go wrong.
perhaps now that I'm unmuted,
Oh,
I can say from a Coronial point of view, of course, I'm always involved when things go wrong, badly wrong, and a patient has died. And looking through at inquest, the consent process, I would much rather see a properly documented full consent process having been performed. And that really assists the medics when they give their evidence, rather than what sometimes you see, which is a patient scrawl across a consent form, and then we can work out whether they actually understood the procedure or not. So I don't think I do agree, and I'm not a doctor, so I don't want to, I don't really understand the implications for clinical practice in terms of time, but as a lawyer, having looked at this recently in terms of an inquest and what was actually consented to and what was explained, I agree with the professor that if it takes a little bit more time to sit down and actually listen to the patient and speak to them, well, and that's what should be done. But again, I'm saying this as a lawyer and a coroner looking back on this forensically, and it's easy for me to do that, to go back through the papers. So I want to tread carefully in those comments.
Joe, thank you very much.
Can I ask in a follow-up on that? How do you know if the patient understands?
You ask them.
But that,
do you understand what it's asked you?
Well, you could come out with some. You could ask me about some matter of law, and I could say yeah, but I don't actually understand.
Well, I ask you, would you explain that back to me, what I've just said? And if you explain it back to me as I have explained it to you, then I can gauge understanding. So
no, that's recall. That's recall. That's not understanding.
Yeah. It's active listening, we call it. So I do it in court all the time, whether they actually understand or not, or they are just repeating back. But I can gauge their understanding from somebody asking them to. That's the way I would normally do it. But
well, I think that's a very subjective thing. I think what you're looking at there are two different things. You're looking at understanding and recall.
Yeah, you can get into this in a lot of detail, or you can simply document that you spoke to the patient and their answers reflected a degree of understanding, and that'll be enough in terms of your as long as it's written down properly.
Can I
think delve into the psychology of it too much.
Can I just point out that none of these issues are unique to Montgomery? The issue of understanding applied in Bolam as well. So the issue is giving a patient an information leaflet doesn't necessarily imply the patient understood what they were agreeing to either. So there is always going to be the issue of whether somebody understood what treatment you were offering them and what its implications were. I think, I don't think things have to be perfect, and you can never prove that they are perfect. And as you've already heard, it's for the claimant to prove that they proceeded with treatment that they didn't understand. If you had told them, explained it to them, and as far as you were satisfied they understood it, and you had documented that they appeared to understand it, that is the test in law, and that's all we need to be able to do.
Thank you, Gordon. I think we would all agree, the clinicians, that we are trying. I mean, the consent really has become a process, and from the time we first meet our patients in maybe the outpatient clinic, our first consultation, we are trying to, and I think most of us are trying to find out what their expectations are at that time. We maybe meet them at a time of a test and we discuss it in more detail, and then prior to the operation. I think I'd like to change. Well, one last question before I hand over to Neil to close. And it's come in from Anthony McBrearty. And it is interesting. We've been talking now for about an hour and a half, and we haven't really mentioned COVID. And Anthony has raised the issue that, with the impact of COVID likely to be felt in the NHS and its staff for a significant period of time, do the panel feel that doctors are currently exposed more so than usual to the legal ramifications given the current changes in practice, such as postponement of non-urgent work, use of virtual clinic, pause in services, and in many cases delay in care delivery as a result of the pandemic? And do you think we are more legally exposed now because of this? Maybe Gordon, what would your feelings be in that, or Neil?
I'm going to comment on this initially and point out that this is really a brilliant question, but also I think it's more than a legal question. It's in that difficult hinterland, to my mind, of where the law meets politics. Because if nobody in the entire United Kingdom can meet the targets set out, for example, in the Health and Social Care Act in 2012, because of a national pandemic which has consumed all of our resources, it strikes me it would be a very, very difficult act for any court to find that an individual trust was in breach of duty that could not be provided anywhere else because of a unique situation. But I'd be very interested to hear what a judge has to say about that.
Well, I mean, ultimately, there may well be cases that will develop the law in this particular area. But there are a number of, under the Coronavirus Act, aspects of life that where changes have by legislation been allowed to occur, and practices that have in the past would regard not been acceptable are now acceptable. So every day we conduct court proceedings by way of Zoom and SiteLink and these things, where in the past that would simply not have occurred. So statute has intervened and has allowed changes to take place to cover this particularly unusual situation. What I think might be the interesting question, though, is beyond those statutory changes, whether or not there will be common law changes to take account of this situation over time. So when things have gone wrong in this period and when legal processes then kick in, will the courts allow a more flexible standard to have arisen in this period or not? That's a matter that I'm just not sure of at the moment. And perhaps, as Gordon has alluded to, that is more than a matter of just of law. It engages a wider sort of public and semi-political debate.
I think time is marching on. I just want to personally thank all the presenters, but I'm going to hand over to Neil to maybe formally close the meeting. Thank you.
Well, thank you very much, Gary. Thank you very much for organising all this. Thank you very much for all the presenters and the time and effort you've put into making the presentations so much fun. And thank you for everybody who's attended. The ASGBI has been delighted to support this, and Gary is our ASGBI rep in Northern Ireland at the moment. And I'd just like to try and welcome everybody into the arms of ASGBI. We not only offer webinars and educational content, but also fellowship of the surgery in general, with works across various associations with guidelines. Most recently, of course, you might have come across some of the COVID support regarding PPE and our prioritization guidelines for those places with limited resources, which many of us are suffering at the moment. It's our centenary year. For those who are members, we were so disappointed not to be able to celebrate our centenary, but we hope to do it next year, and I'd welcome everybody to join, and everybody who has an idea and something they wish to pursue within the organization is very welcome indeed. Thank you very much to everybody. Thank you very much, Gary. A great webinar.